name is Lauren Fields. I lead the domestic litigation team here at Roth Davies LLC. In this video, I'm going to be discussing family mediation. One of the resources that many courts have for families is the option to go to mediation. Mediation involves both parties and a neutral third party that tends to help facilitate agreements between the two parties. Typically, the mediator will request that your attorney provide him or her with a statement about what he or she perceives to be the outstanding issues in the case. The mediator reviews those statements prior to mediation and hopefully comes into the mediation with an understanding of what issues need to be resolved. Typically, your attorney will not attend mediation with you unless you request them to do so. This is something that I usually just have parties go to, especially if it's a court-appointed mediator. I have had situations where a client has requested my attendance at the mediation if it's a private mediator where they're paying a little bit more for the mediation. Or I've had clients request my attendance because they're fear of intimidation by the other party. In that case, I simply let the attorney know that I would be there and that they also can appear. That's rare, but it's appropriate in certain cases. Once the mediation starts, typically the mediator will list out several issues that he or she perceives need to be resolved. Then you and your significant other will start going down the line to see what you can get resolved and what you cannot get resolved. One advantage of a mediator is that he or she is typically familiar with the judge that is in your case and is able to give you insight as to what the judge might do. Sometimes a party hearing what that person believes the judge will do will help lead towards an agreement between the parties on that specific contested issue. Mediation is not binding, and after leaving mediation, the agreements reached can be changed. Typically, if parties do reach agreements in mediation, I try to immediately journalize them and submit them to the court for consideration. This prevents parties from going back later on and changing their minds on things that they agreed on. However, sometimes it is appropriate to change your mind on what you agree on in mediation, and that is fine as well depending on what it is. A step further beyond mediation is sometimes called conciliation. Sometimes the courts can order conciliation instead of mediation. The main difference between conciliation and mediation is the agreements reached in conciliation will be binding and will become the court order. If agreements are not reached in conciliation, the conciliator may give recommendations to the judge. If you have any questions about the mediation process, conciliation process, or what to do to prepare for either of them, please feel free to give me a call at 913-451-9500.